We are very, very fortunate to have with us this evening three distinguished jurists who are sitting on the panel. Serving as Chief Justice tonight, the Honorable Potter Stewart from the United States Supreme Court. With him on the bench, serving as Associate Justices, Justice Phyllis Kravitch from the United States Court of Appeals, Fifth Circuit, and Justice Louis Pollack from the United States District Court of the Eastern District of Pennsylvania. We are also very fortunate to have with us this evening two very talented teams who worked very hard. Representing the petitioner this evening, the Somerville Bar Review Club, with oralists Eric Cromartier and James Sultan. And on the briefs, Peter Goodman, Jorge Del Cabo y Gonzalez, Leo Lorenstein, and Elise Blaster. Representing the respondent this evening is oralist and the Marshall Club, oralist Robert Kantner and Marcia Remai. With them on the brief, Richard Swanson, Sylvester Turner, Mark Carroll, and John Eichmann. I have two requests this evening. First, when the judges enter, prior to the beginning of the argument, there will be 2 or 3 minutes when you can take photographs. Please, after that time, do not take any more photographs during the argument. Secondly, please refrain from any applause until the end of all the arguments so that it won't interrupt the proceedings. And finally, I would like to invite you all to a reception following this argument in the Roscoe Pound Hall on the 2nd floor. Thank you very much.
Oyez, oyez, oyez! The Honorable, the Supreme Court of the United States is now in session. All persons having business before this court shall come forward and give their attention, and they shall be heard. God save the United States and this honorable court.
Sit down, I guess.
Yeah, right here.
Through. Just exactly, yeah. The next case is number 79-1821, Fenton Oil Company Incorporated petitioner against Amar Petroleum Company respondent. Counsel may proceed when you are ready.
Mr. Chief Justice, may it please the court. My name is Eric Cromartie. Together with my colleague James Sultan, we are here to represent the trustee in bankruptcy for Fenton Oil Company. This case presents the question of whether an American company sued in American courts by a foreign state-owned corporation can recover the damages that it has suffered as a result of that foreign company's illegal commercial activities. Fenton Oil Company is entitled to a hearing on the merits of its federal claims. Amar Petroleum is not immune from suit under the Foreign Sovereign Immunities
Well, that's
Act.
sort of a oversimplified and emotionally appealing statement of the question presented, isn't it? Actually, there are two or three rather complicated legal issues involved in this case.
Your Honor, that is absolutely correct. It is nevertheless Fenton's belief that Fenton is entitled to
Well, I know it is.
the consideration of by this court the merits of its federal claims. It is also our belief that the facts will show that Fenton's being deprived of suit against Amar under the Foreign Sovereign Immunities Act was an error by the lower court because Amar Petroleum's conduct was clearly commercial in nature. In addition, there is no grounds in this case for the courts or courts to abstain from deciding this case on the merits on the ground of the Act of State Doctrine. This case arises out of a long history of commercial dealings.
There's a preliminary question involving the very jurisdiction of this court. Is your colleague going to deal with that?
No, Your Honor, I will deal with that issue. The issue
I don't think
you
you've mentioned it, have you?
No, not yet, Your Honor. The issue to which you refer is the Clinton Amendment. The Clinton Amendment purports to deprive this court of jurisdiction to hear this case. As such, the Clinton Amendment is an unconstitutional usurpation of the judiciary's role.
Mr. Cromartie, if I may ask, is there perhaps an antecedent jurisdictional problem even before the Clinton Amendment? Maybe you can clear something up for me, but I'm a little puzzled by. How did this case get to the Court of Appeals? Was there a final judgment in the district court?
The final judgment in the district court was a dismissal on the grounds of lack of subject matter jurisdiction, which was then appealed to the Court of Appeals, which summarily affirmed the dismissal by the district court. Cert was then granted by this court to hear the federal questions involved.
That was a dismissal of a counterclaim, is that right?
Yes, it was.
Isn't the principal action still in the district court?
The principal action is still in the district court, Your Honor. However, Fenton's claim will have no opportunity to be heard, and it is final judgment as to Fenton's counterclaim, which is treated as a direct claim.
I couldn't find any light shed by the record on that, but it struck me that there must have had to have been some kind of certification by the district court that there was a separable final determination with respect to that counterclaim for the First Circuit to have had anything to act on. But I take it that's beyond the purview of our concerns at this point.
Yes, Your Honor. In attempting to deprive this court of jurisdiction to hear a case in which this court has granted certiorari, Congress has acted unconstitutionally in two separate yet interrelated respects. First, in its assertion of an unlimited congressional power under Article 3, Section 2, to remove questions of federal law from this court's jurisdiction, Congress has fundamentally undermined the system of checks and balances upon which our entire federal system of government rests. Second, in its attempt to dictate to this court the specific result which this court must reach in the case of Fenton Oil Company v. Amar Petroleum Company, Congress has also overstepped the boundaries of legislative action by attempting to usurp to itself the judicial role.
Is there any case in which this court has said that Congress lacks the power to withdraw a case from this court's appellate jurisdiction?
Indeed, there is, Your Honor. In United States v. Klein, this court held that Congress may not withdraw jurisdiction from the Supreme Court in order to achieve the means, or achieve the end, actually, Your Honor, of dictating the specific result in a specific case. That is exactly what Congress has done in this case.
Wasn't Klein a case in which Congress fashioned a substantive rule of decision?
Yes.
Yes, Your Honor, it was. They said Congress...
That's not this case, is it?
No, but it is similar, Your Honor, in that what this court is being commanded by Congress to do in this case is to take the claim of Fenton v. Amar, decide whether the case was dismissed on the Act of State grounds, and if it was, dismiss the action. Act of State doctrine is a particularly inappropriate place for Congress to be dictating to this court the result it must reach. The Act of State doctrine touches on the principles of separation of powers, and that decision is a decision for the judicial branch and the judicial branch only. Under the constitutional plan, constitutional questions are to be decided by the Supreme Court. Congress has attempted to overstep its boundaries in instructing both the lower court, in effect, and this court to decide in a particular manner on the Act of State doctrine.
Well, isn't that, in a way, begging the question? The first and basic question, I suppose, is what does the second paragraph of Section 2 of Article 3 of the Constitution mean? And if it means that Congress could do what it did, then nobody makes very much sense saying it's unconstitutional.
Your Honor, there is no historical evidence to indicate that the exceptions clause was intended to allow Congress to act in the manner in which it is done here. The historical evidence indicates that the framers were concerned with protecting the right to jury trial and allowing Congress to make certain exceptions to the jurisdiction of this court as to matters of fact, not matters of federal law.
What authority do you have for that contention?
The authority we have for that is certain statements of the Founding Fathers, James Mason, James Wilson, in our brief. In addition, the entire constitutional plan implies that such a power could not possibly have been intended. It was the intention of the Founding Fathers to create a system of government where there were checks and balances in order to prevent the possibility of a legislative despotism against which the Founding Fathers had just fought a revolution. The power which Congress asserts in this case under Article 3, Section 2 would allow Congress to remove from this court's jurisdiction all federal questions, leaving this court only with those few enumerated cases within its original jurisdiction. Such cannot possibly have been the intent of the founders and is contradictory to the rest of the Constitution. Would also point to Article 6 of the Constitution, which requires that there shall be one supreme federal law. It was early interpreted that that one supreme federal law was to be declared by the Supreme Court. This court is noted quite
But that's even perhaps less clear from reading the Constitution than the language of the second paragraph of Section 2 of Article 3 seems to be.
Even to the extent that it is less clear, it is more in accord with the Constitution read as a whole.
It was established early in the game under the leadership of Chief Justice Marshall, but it's perhaps less explicit than do the words of the second sentence of the second paragraph of Section 2 of Article 3 seem to be. Isn't it true?
That may be so, Your Honor, but it is more in accord with the obvious intention of the framers to protect individual rights and liberties against the government, as well as to provide for the efficient functioning of our federal government.
You would have us disapprove the unanimously adopted language of Chief Justice Wade and McCardle?
Your Honor, I believe that McCardle does not hold, as the congressional sponsors to the Clinton Amendment assert, that Congress may remove questions of federal law entirely from this court's jurisdiction. In McCardle, all that was removed was one particular route to the Supreme Court. As that court noted in its closing paragraph in that very opinion, there were other means, well, there was another means by which McCardle could have brought his claim before the court, and the court so held the next term in Ex parte Yorger in a similar circumstance.
But the question is whether the Congress has the power to remove this court's authority to review a particular case which is already docketed here. And that was exactly the issue determined in McCardle, was it not?
Your Honor, the court determined in McCardle that McCardle's habeas corpus petition could not be heard on appeal. In this case, it's very different. Fenton Oil Company's claim cannot be heard at all if it's not heard on appeal here. There is no other route by which Supreme Court review of the Act of State question or the Foreign Sovereign Immunities Act question in this case can be achieved.
Why is Fenton entitled to another route? Why? Fenton has already had one court to appeal to. What constitutional principle is at stake that guarantees it a second appeal?
Fenton is not constitutionally guaranteed a second appeal. The Supreme Court could, in its discretion, have refused to grant certiorari in this case, but the Supreme Court did grant cert, and it is Congress's usurpation of this court's power which is the constitutional violation in this case. If I may illustrate the possible difficulties of the rule that Congress asserts in this case, let us examine another judicially created doctrine of abstention which also regards the proper definition of the separation of powers, the political question doctrine. Assume that the mayor of Chicago used tax funds to support and publicize the candidacy of a particular senator for president. Let us assume that a suit was then brought against that mayor alleging misuse of public funds. That senator then introduces into Congress an act which declares that in this particular case the mayor's actions are a political question beyond the jurisdiction of the courts. would clearly be an unconstitutional use of the legislative
Could be
power.
vetoed, I think, in the present.
I think, Your Honor, that that would be a virtual certainty. I would also note, however, that the Clinton Amendment was passed over presidential veto also, even though it asserts to act for the president's particular realm of foreign affairs.
Mr. Cromartie, what is the source of the act of state doctrine? That is the act of state doctrine constitutionally compelled, a matter of federal common law or international law?
It's, Your Honor's question, first of all, it is not constitutionally compelled,
All right.
and this court has recognized it. It is a judicially created doctrine by the federal courts. It was designed to allow the court to give the proper respect and to the executive's conduct of foreign affairs, to stay out of that realm which is given by the Constitution to the executive. And Your Honor also brings up the point, or illustrates the point, that the act of state doctrine is a particularly inappropriate place for Congress to act, because the act of state doctrine is intimately concerned with the proper delineation of the separation of powers. That is a question which is a constitutional question of first importance, to be decided by this court and this court only. And in the political question hypo that I posed, and in this very case, Congress has attempted to define the proper boundaries of the separation of powers, and has attempted to dictate that result to this court. That is in violation of the constitutional plan. The evils of a selective removal of jurisdiction in controversial cases are only too apparent. For example, in the early 1950s, this country's school systems were largely segregated. This court's decision in Brown v. Board of Education took a giant step forward in bringing racial integration and racial equality into education. This court might never have been able to reach that decision if a Congress motivated by the political concerns involved had been allowed to accept from this court's jurisdiction consideration of that case.
Of course, Fenton's claim isn't a constitutional claim at all, is it? I mean, doesn't that significantly differentiate this problem from the parade of horribles that starts with what if Congress had tried to prevent this court from dealing with racial segregation?
No, Your Honor, I don't believe it does. If I may pose another hypothetical, let us suppose that Fenton Oil Company, instead of suing Amar Petroleum Corporation for price fixing and driving it into bankruptcy, had sued Exxon and Shell and various American oil companies.
Then you wouldn't have the act of state doctrine involved, or would you?
That's correct, Your Honor. But let
And
us...
so the Clinton Act wouldn't apply?
No, but let us suppose that Congress passed a similar statute saying that in that particular case, price fixing would not constitute a violation of the Antitrust Act. That would not be the proper role of the legislature. The legislature is to enact laws of general application. It could have acted in this case to amend the Foreign Sovereign Immunities Act to provide that all suits against foreign instrumentalities, whether they be of commercial or political nature, would be barred.
Or, as you suggest, it could have amended the Antitrust Act to carve out this situation and give it prospective or retroactive effect.
Absolutely, Your Honor, but Congress did not do that. Congress acted to deprive Fenton Oil Company and Fenton Oil Company only of the benefit of the law.
You would acknowledge, I take it, what you're saying is that there'd be no problem at all if Congress had legislated before the Court of Appeals had acted on Fenton's appeal from the dismissal of its counterclaim in the district court. If Congress had legislated before the Court of Appeals judgment, in just the sense that it did, so that it was long before there was any case docketed in this court, there would have been no problem with the anticipatory withdrawal from this court of appellate jurisdiction.
If Congress had acted in the way it has acted in the Clinton Amendment, or if it acted by amending the Foreign Sovereign Immunities Act?
No, if it had acted as it did in the Clinton Amendment.
That also would be an unconstitutional usurpation of judicial power. It would not be an act of general application. It would be an act, in that case, instructing the Court of Appeals how it must find in a specific case, and would also violate the Constitution.
No, I was putting my question in terms of just as this legislation is, a specification with respect to this court's appellate authority, not touching the Court of Appeals appellate authority at all. That is to say, I'm wondering if your issue doesn't narrow itself down to the question of whether Congress is entitled to interfere with the appellate authority of a court which is already seized of a case, and nothing more.
No, Your Honor, it does not.
Would Congress, not as a matter of practical possibility, but as a matter of pure constitutional power under Section 1 of Article 3, Congress would have the power to eliminate all courts of appeals, wouldn't it?
They do, Your Honor, except for the Supreme Court.
Well, I'm talking about courts of appeals or district
Your Honor.
courts. It could just eliminate them entirely tomorrow as a matter of constitutional power, could it not?
Well,
It would have to give the judges of those courts a certain lifetime tenure, I suppose, and no reduction in their compensation. But the Constitution doesn't create those courts. It authorizes Congress to create any kind of federal courts that it chooses.
Absolutely,
And presumably,
Your Honor.
therefore, to eliminate any that it's already created. You would concede that, wouldn't you?
absolutely, Your Honor. Although that isn't the case before us now, it is certainly possible that there could be some concerns now, 200 years after the founding of our country, that removing all federal courts would implicate certain constitutional concerns of due process. But that's not what Congress has done here. What Congress has done here is attempted to legislate a judicial result in a particular case. Particularly important, and it doesn't matter whether it was in front of the Supreme Court or a court of appeals, that people like Fenton, or companies like Fenton, and people like the civil rights protesters in the 1960s, be able to go to an independent, non-political, non-partisan judiciary to get a decision that is above the political turmoil that has led to the Congress enacting the Clinton Amendment and attempting to deprive Fenton of the day in court which this court had already granted it. It is particularly important in the field of the active state doctrine or the Foreign Sovereign Immunities Act that the Supreme Court be allowed to fulfill its constitutional function under Article 6 of declaring the one supreme federal law. Because as this court recognized quite recently in Sabatina, this is an area of particular importance to foreign sovereigns, that they know what their liabilities will be when they enter into American courts. The possibilities of being able to selectively remove all controversial cases, whether they involve constitutional claims in and of themselves or not, should force this court to exercise its jurisdiction and to find this attempt by Congress unconstitutional. However, given the wording of the Clinton Amendment, it is possible for this court to hold that the Clinton Amendment is not applicable to this case, since the lower court rested its decision on a dismissal for want of subject matter jurisdiction under the Foreign Sovereign Immunities Act.
Do you really think, in view of the very specific legislative history of the Clinton Amendment, the court could responsibly do what you submit?
Your Honor, the court could certainly read the opinion.
Of course, with 5 votes, we can do anything, I suppose.
Your Honor,
Or in this case, 2. Yeah.
yes. Whether the court finds that the Clinton Amendment applies or not, it is absolutely necessary to preserve an independent judiciary, that this court hold that the Clinton Amendment does not prevent the court from hearing this case, the merits of Fenton's federal claims, which this court had already decided to hear. Thank you.
Thank you very much. You may proceed.
Mr. Chief Justice, and may it please the Court. Having enlisted the aid of American courts to enforce a commercial contract, the Amar Petroleum Company must be held legally accountable for the price fixing which dictated the terms of that contract.
Mr. Sultan, the record does not make it clear as to what the terms of the contract were. Did the terms of the contract which Fenton signed link the price to be paid with OPEN?
Your Honor, you are absolutely correct. The record is not entirely clear. To the extent that we have information, there was a price stipulated in the contract, which indeed happened to be the very price which was dictated by the OPEN oil cartel.
But it was X dollars a barrel, wasn't it?
Yes, Your Honor,
It didn't incorporate by reference.
No, Your Honor, it did not. The district court found, however, and Amar does not deny, that it has participated in an international conspiracy to inflate the price of crude oil. That scheme, which has netted hundreds of billions of dollars to Amar and its co-conspirators, has had a catastrophic impact upon the Fenton Oil Company and upon the American economy as a whole. Fenton has been driven into bankruptcy, and all Americans have been forced to pay ever higher prices for the necessities of life. Yet Amar claims a special privilege to carry out this destructive conduct with impunity because it is predominantly owned by a foreign government.
Its first argument is that quite apart from its ownership, that the antitrust laws of the United States of America are simply not applicable to its actions, or its actions along with its concerted actions with others, non-defendants here.
Yes, Your Honor.
That's its first and more basic argument before you get to sovereign immunity or the act of state doctrine, isn't it? Isn't that correct?
If you'd like me to address that first, I'd be happy to do so.
Do I misunderstand their argument?
You are correct, Your Honor, that the antitrust argument, like the foreign sovereign immunities argument, is a threshold jurisdictional argument, while act of state is an
affirmative defense.
Yes, Your Honor, and it's a doctrine of abstention. With respect to antitrust, as the lower court found, the actions of Amar in participating in this price-fixing cartel clearly meet the direct effects test articulated by Judge Hand in the Alcoa case and endorsed or cited with approval by this court in the Continental Ore case. The effects in the United States are, as the district court found, that there has been widespread unemployment and serious inflation resulting from the actions of this cartel, including the actions of Amar. And more specifically, with respect to Fenton, the company has been driven into bankruptcy. To the extent that this court would find that the direct effects test is not enough, and that this court must follow the suggestion of recent circuit court opinions, for example, the Timberlane, Ninth Circuit and Timberlane, there should be some sort of a balancing test involved. We would assert that that balancing test is clearly met here by Fenton. The magnitude of the effects in question upon American commerce are such that this court cannot sit idly by and permit a foreign sovereign engaging in a commercial activity to, with impunity, victimize American corporations and the American economy. Moreover, to the extent that this court would take cognizance in doing that sort of a balance of any particular or possible ramifications in the foreign policy arena, which it must do under the Act of State doctrine, there is no indication in the record that the government of Atlantis or the government of the United States has expressed any concern whatsoever about the outcome of this particular commercial litigation in our courts.
But don't you think we can pretty well guess that there might be a little concern on the part of the government of Atlantis?
Your Honor, while this court may make such a guess, we would assert
that's something that hardly need be a matter of record, does it? Need it?
Your Honor, to the extent that any antitrust defendant which is found to be in per se violation is unhappy with that particular result.
What's its potential liability?
Its potential liability is $90 million under...
Treble?
Yes, Your Honor.
$270 million?
No, Your Honor, I'm sorry. It's $30 million treble.
$30 million treble.
And that, of course, would be within the discretion of the district court.
Certainly.
To find that that is a justifiable amount.
Mr. Sultan, it's your contention then that this was a commercial activity and was not governmental or political?
Yes, Your Honor.
To go. And even in light of the problems that we have in the world today, it is still your contention that this did not have political underpinnings. Is that correct?
No, Your Honor, it is not. While the commercial activities of the Amar Petroleum Company may very well have political ramifications in a world so dependent on this crucial energy source, under the Foreign Sovereign Immunities Act, the activities of that corporation are clearly commercial in nature.
What was the primary goal? Wasn't the primary goal political? The OPEC countries wanting to keep their products and to control them from foreign interests?
No, Your Honor, we would submit that the primary purpose of this organization's activities was to raise the price of crude oil by more than 400% and thus obtain a tremendous windfall for their membership. To the extent that there was a political purpose articulated by the government of Atlantis, that political guise for this commercial activity cannot, under the Foreign Sovereign Immunities Act, alter the commercial character of the conduct.
That's your point, that regardless of the motivation, even though the motivation was concededly political, the test is not the motivation, but rather the nature of the activity.
Yes, Your Honor, it is not our point. It is explicitly within the statute.
That's what you say. The statute is the test of the statute.
In Section 1603 of that Act, the Congress explicitly held that the courts, in interpreting it, must look to the nature of an activity and not its purpose in determining whether or not it is commercial. In this case, Amar's price fixing falls squarely within that commercial exception to the FSIA. Amar is a corporation engaged in the production and sale of crude oil on the international market. Like other major oil companies, it sells its product for profit to benefit its corporate shareholders. The fact that a majority of stock in that corporation is owned by the government of Atlantis, and the fact that the corporation has participated in a price-fixing cartel does not alter its commercial status under that statute.
Mr. Sultan, suppose what was alleged in the counterclaim filed by your client was not a fixing of prices at some very high level deemed by you to be excessive. Suppose it was a withdrawal of crude oil from the market altogether for some period of time with a view to using whatever leverage that would have to persuade this government to take a more accommodating role with relation to issues between the United States and Atlantis. Would the economic impact of such a boycott on Fenton or some other would-be purchaser of crude be viewed by you as merely the damage falling from a commercial decision taken by Amar?
No, Your Honor, that would be a very different case for two reasons. First, it is not clear that such conduct would constitute a violation under our antitrust laws, and of course we would have to meet that requirement in any event.
If it had all of the conspiratorial overtones of an OPEN-taken decision?
If it was found to be a boycott which had the effect of reducing competition, then I guess it would fit the antitrust requirement. However, what you suggested falls much more closely to the political line under the FSIA.
Because of its purpose?
No, Your Honor, because the act that you suggest would not, and the only test suggested in the FSIA's legislative history, or one test suggested, is that courts determine whether the act in question is one which is ordinarily carried out by a private company. And what you would suggest sounds like an act which in fact would be quite harmful to the commercial or profit-making purposes of a corporation. By withholding their product from the market, presumably they would be making no profits whatsoever. In this case, we have price fixing, which is the essence of commercial activity, to try to raise prices and therefore increase profits.
As I understand it, this part of your argument is based squarely on 28 United States Code, section 1603D.
Yes, Your Honor, and as that is incorporated in 1605 and 1607, which authorizes...
But the definition is in 1603D,
yes, Your Honor,
of commercial activity. And
yes, Your Honor.
In answer to the question of my colleague, your point was that not selling something is not generally considered a course of commercial conduct.
Well, Your Honor, the legislative history, the report which was enacted by the House and Senate Judiciary Committees which approved the legislation provided a little bit more guidance to the courts.
Well, we begin with the words of a statute, generally,
of course, Your Honor.
At least in our old-fashioned way, we sometimes do.
Of course, Your Honor.
Yeah.
And under the words of that definition, Amar's conduct is commercial in nature, and the lower court therefore was mistaken in finding Amar immune from Fenton's counterclaim under that particular statute. Amar's argument in the alternative that American courts must abstain from hearing the merits of this counterclaim under the Act of State doctrine must also be rejected. If this court were to adopt the position taken by Amar that American courts must close their eyes to price fixing undertaken by foreign sovereigns engaged in commercial businesses, American companies engaged in international commerce would be at the mercy of their foreign customers and suppliers. Under such a rule of law, any foreign corporation could break a contract, commit outright fraud, or engage in anti-competitive activities which harm an American corporation simply by obtaining from a foreign sovereign a decree purporting to authorize or require such conduct. It was never the intent or purpose of the Act of State Doctrine to provide such a blanket exemption to all destructive activities which foreign sovereigns might choose to inflict upon the United States in the commercial sphere. As the plurality of this court recognized in the Dunhill case, with the support of the executive branch.
It wasn't a plurality of the court. It was a plurality of the majority, wasn't it? It was 4 members of the court.
Yes, Your Honor. It was
a minority of the court.
Yes, Your Honor. It was a minority of the court which recognized the commercial exception in that context with the support of the executive branch.
But Act of State Doctrine usually applies to judgments or decrees or acts of a foreign country. Now, here we have Amar, which is a corporation.
Yes, Your Honor.
And this is owned by an agency of the foreign country.
Yes, Your Honor.
And it is not, therefore, the foreign country. It's not a judgment of a court of a foreign country or really an official act of a foreign country, is it?
Your Honor, to the extent that this court would find that the acts of Amar, in fact, are not the acts of a foreign sovereign, the Act of State Doctrine would not be implicated at all.
But the course of conduct that made Amar now a wholly owned subsidiary of the government itself was the conduct of a foreign sovereign, was it not?
Yes, Your Honor, and we do not dispute that particular finding. Under the Act of State Doctrine, however, such a blanket exemption for commercial price fixing cannot be recognized. Not only because the plurality of the court in Dunhill determined that in a world where governments are playing an increasing role as merchants directly in the commercial sphere, that such a commercial exception must be recognized. Since that decision, or you're right, Your Honor, it was not a decision, it was an expression of opinion by 4 justices in that case, Congress several months after that enacted the FSIA. That statute was premised on the policy that all those, regardless of their identity, who participate in commerce with the United States be subject to a single rule of law. That is, that courts should look not to the nature of the activity, not to the identity of the actor, but to the nature of the activity itself.
And not to the motivation behind the activity.
Yes, Your Honor. This court recently, in the Pfizer case, articulated a similar policy.
That was a plaintiff.
Excuse me, Your Honor?
It's a case I think you're talking about. That was a plaintiff coming into our court.
Yes, Your Honor, that's correct. It was the court there found that a foreign sovereign could sue for treble damages could sue an American corporation for treble damages under our antitrust laws. The reasoning of the court in that case was that a foreign sovereign engaged in the commercial realm was just as susceptible to be victimized by commercial price fixing or other anti-competitive conduct as was a private corporation. And therefore, the fact that it happened to be owned by a sovereign or was a sovereign should not prevent it from obtaining redress for its injuries. The converse, of course...
There was no question there of either, certainly there wasn't of sovereign immunity, and there wasn't any question of an act of state, of the interposition of the Act of State Doctrine, nor of the coverage of the antitrust laws, generally, was there?
No, Your Honor.
None of the questions that are the 3 issues in this case.
Your Honor, I would suggest that the case is relevant to the extent that it indicates the court's...
Let alone there was no Clinton amendment in that case.
There was not, Your Honor. To the extent that that case indicates the court's view that within the commercial sphere, that the fact that a business is being run by a government rather than by a private corporation should not alter the rights and responsibilities, and in that case it was the rights of a sovereign under American law. Once again, in following the lead of Congress, the court there found that it was not the identity of the actor, but the nature of its activities that were significant. And in this case, just as a foreign government can be victimized by American drug companies getting together to fix the price of tetracycline and selling it for a fixed price, American companies can be victimized by foreign sovereigns engaged in the oil business getting together to fix the price of oil.
Generally speaking, laws passed by the Congress of the United States are not applicable to Englishmen or Frenchmen living in England or France.
They are not, Your Honor, except to the extent that the activities which occur outside of our borders impact directly.
Well, they certainly do, including those of Englishmen and Frenchmen.
I'm sorry, Your Honor?
Well, they certainly do. That's increasingly true. But it's not limited to the Middle East or to the OPEN nations.
Not at all, Your Honor. To the extent that any, under our antitrust laws at least, to the extent that activities of any foreign corporation, public or private, impact directly and significantly upon United States commerce, as Amar's activities do here, American law may be brought, those claims may be brought in American court.
Well, in the Pfizer case, though, it was purely commercial activity. There was no question there of any political motivation on the part of the American drug companies, was it?
That's correct, Your Honor. The FSIA requires that courts do somehow apply that line. Courts have no choice but to decide that an activity is either commercial or non-commercial. There is no third option under that act. Here, Amar's activities under the definition in 1603 must be deemed commercial.
Do you suppose that Congress, when it enacted the Federal Sovereign Immunity Act, had in mind that it was doing something about the active state doctrine?
No, Your Honor. While Congress expressed in the legislative history a fear that entities which no longer would be immune for their commercial conduct under the FSIA might, as they put it, circumvent the intent of Congress by going through the back door of the active state doctrine, there was no intent in that legislation to alter the active state doctrine.
It's your submission that these are two quite separate issues.
Yes, Your Honor.
With some perhaps relationship between them, but my question to you, and you think that's the correct analysis of the situation. My
Yes,
question to
Your
you was, do you think Congress was maybe a little mixed up in its analysis of it?
To the extent that Congress, no, Your Honor, I don't think Congress is mixed up because Congress believed that the active state doctrine, a discretionary doctrine of abstention, remained properly within the hands of the judiciary, and it was not subject to the same sort of blanket considerations which underlay immunity under the Foreign Sovereign Immunities Act. To the extent that this court does not choose to approve a commercial exception to the active state doctrine, under an ad hoc balancing test of the relevant facts at issue here, Fenton's counterclaim still must be heard.
Mr. Sultan, this case, as I understand its posture, is one in which two lower courts have concluded that the activity in question was not commercial. Is there any ground for our court concluding that those concurrent determinations were clearly erroneous?
Yes, Your Honor. The courts, in making that determination, clearly ignored both the language of Section 1603 and the legislative history of the FSIA.
Do you think those were findings of fact in the first place?
No, Your
Because
Honor.
unless they were findings of fact, my colleague's question has less force, I think.
Your Honor, we would submit that the legal conclusion that under the FSIA, Amar's activities are non-commercial is not a question of fact. The court spoke about the purposes of Amar's activities, and it simply ignored the requirement that courts are to look at the nature of the activity and not its purpose, and thus its finding was erroneous and properly reviewable as a matter of law by this court.
Didn't it precisely say that the purpose was quite manifestly an ordinary commercial one, but that its nature was governmental?
To the extent that it did that, those were its words, Your Honor, we would submit that the lower court indeed was confused. That, in fact, what it was looking at was a commercial activity, that is, commercial price fixing, and it interposed the words of, and that should surely not be followed as determinative of interpretation of the FSIA by this court. Under an ad hoc balancing test.
Your earlier point was that that's one reason this court is here, to correct the errors of other courts.
Absolutely, Your Honor. Without any interference by another branch of government. Under under the type of ad hoc balancing test endorsed by this court in the Sabatino case, Fenton's counterclaim still requires to be heard. The active state doctrine does not require abstention. First, it must be remembered that this is indeed a counterclaim. It is Amar and not Fenton which commenced this litigation. Amar came into an American court as a corporation attempting to enforce its fixed price contract. To the extent that it has attempted to invoke the privileges of American law, it would be anomalous for this court to allow it to turn around and assert an immunity from that same rule of law when it is called to task on the price fixing which underlay the fixed price it attempted to enforce. It must be kept in mind as well that we are talking about commercial activity here. And even if there is no blanket exception recognized by this court, that must be an important factor taken into account in any ad hoc balancing test. Moreover, the effects involved here in the United States are extreme and considerable. That is also a factor to be considered. Finally, with respect to the political ramifications, and it must be remembered that the active state doctrine is designed to protect executive independence in the field of foreign policy. There has been no indication from the executive of this nation that at no point in this case has the executive branch interfered to assert that this case should be not heard by American courts.
Indeed, the indication is to the contrary, isn't it?
Absolutely, Your Honor. By
presidential veto.
By vetoing the Clinton Amendment, the executive could not more clearly indicate his non-concern with this court's adjudication of this case. Moreover,
if we had such an indication, you would then think that this court ought to affirm.
No, Your Honor, it is the judgment of this court, the judiciary, must apply the Act of State doctrine, not the executive.
Would we have a different case if the Clinton Amendment had been recommended to the Congress by the President?
Your Honor, that might somehow alter the balance if, in fact, what could be read into that is executive concern. But ultimately, this court must decide.
That's kind of resurrecting the Birnbaum doctrine in a way,
Mercy and exception? No, it is not, Your Honor. The courts have recognized that even though the court must make the ultimate decision, the position of the executive with respect to the effect on foreign policy is a factor to be taken into consideration. That is all that we assert. Atlantis also has taken no position before this or any other court during this litigation to express any concern over the outcome of the litigation or to claim that, in fact, Amar's conduct constitutes an act of state. Finally, OPEN, which respondents claim will retaliate in a horrible and intolerable fashion if this court allows the merits of our claim to be heard, has not indicated any concern whatsoever with the outcome of our particular
Well, if that is the sort of weapon they use, they would hardly be filing an amicus brief in this court.
Your Honor, neither through that particular vehicle nor any other has OPEN indicated a concern. Therefore, Your Honors, it is Fenton's position that this court must allow the counterclaim to be heard before the district court. Thank you.
Thank you, Mr. Sullivan. Counsel for the respondent may proceed when you're ready. You may proceed.
May it please the court. My name is Robert Kantner. Along with Ms. Remai and our colleagues on the brief, I represent the respondent, Ames Petroleum Company. Your Honors, this court does not have jurisdiction to review the decision below. Amar asserted in the district court and reasserts here that Fenton's counterclaim suffers jurisdictional disabilities under the Sherman Act, as I will elaborate a little later, and under the Foreign Sovereign Immunities Act, as Ms. Remai will argue. But the passage of the Clinton Amendment, which Congress clearly intended to apply to this case, necessarily renders those issues of secondary concern because it removes this court's jurisdiction to review the decision below. The Clinton Amendment, Your Honors, removes until 1982 the jurisdiction of this court to review any case dismissed by the district court on the grounds of the Act of State doctrine, which dismissal was affirmed by the Circuit Court of Appeals. Fenton's counterclaim presents such a case and must be dismissed for want of jurisdiction.
Do I understand you to be saying that we can keep the case on the docket until 1982 and then review it?
Not at all, Your Honor. I'm saying this court must dismiss the case for want of jurisdiction.
I thought I understood you to be saying the statute only had effect until 1982.
No, Your Honor. By my reference to 1982 simply referred to the length of the Clinton Amendment's operation. Its effect in this particular case is to remove the court's jurisdiction. It applies to any case which is filed before the 1st of 1982.
Because its purpose was to dictate to this court how to decide a particular litigation.
Insofar as removing this court's jurisdiction to review a case leaves that case as the circuit court left it, only in that sense, Your Honor, does it tell this court how to decide it. It does not, as the statute in question inclined, tell this court what effect to give to evidence or attempt to impose in a post hoc fashion a rule of decision. It simply exercises Congress's constitutional authority to make exceptions to the court's appellate jurisdiction. It does not, Your Honor, in any sense tell this court how to go about deciding the case, other than by removing its jurisdiction, it tells the court it does not have power, as the Constitution expressly provides.
You read the legislative history of the Clinton Amendment as suggesting that to Congress was a matter of indifference how this counterclaim was disposed of?
No, Your Honor. I think, first of all, Congress was concerned that the very time it might take for this case to be decided was in and of itself a potential harm to its efforts to establish an energy policy. I think quite clearly Congress would prefer that this counterclaim be dismissed, because I think that might make its efforts a little easier. But I don't think Congress's power in any sense depends upon whatever predilection it might have regarding the outcome of the case.
Well, and your point is that this case has been decided by two courts, two
That's
federal
correct,
courts.
Your Honor.
Not by Congress, but by courts.
That's correct. And I don't think Congress is attempting to decide the case. It's simply exercising its power to make exceptions to this court's jurisdiction so that it may pursue, unhampered by judicial precedent and possible foreign reaction thereto, questions which are of a very political nature.
Why isn't Congress attempting to decide this case by cutting off any review by this court? Your opponents argue that this has deprived them of a constitutional right, that this is a constitutional question.
Quite the contrary, Your Honor. As I understood counsel for the petitioner, his point was that the Clinton Amendment was unconstitutional because it was an unconstitutional invasion of a judicial province. He did not assert, Your Honor, that Fenton had a constitutional right to review before this court.
Now, would you concede that if Fenton had a constitutional right, that then Congress would not have the right?
If Fenton had a constitutional right, yes, Your Honor, then we would have a much different case, because there would be the question of whether Congress could, by passing an exception to the court's jurisdiction, violate an independent constitutional provision. But that's not, Your Honor, I think the case we have before us.
Couldn't do it.
Marbury v. Madison, Your Honor, simply says that once the court has jurisdiction, its duty is to weigh statutes in terms of the constitutional requirements. I do not think that Marbury v. Madison necessarily means that Congress cannot accept this court's jurisdiction.
Appellate jurisdiction.
Appellate jurisdiction, that's correct, Your Honor.
Mr. Kantner,
yes, sir.
If Congress had legislated instead of the Clinton Amendment as it actually was enacted, if Congress had specified that the court's authority with respect to the litigation entitled Fenton Oil versus Amar, this court's authority was restricted to a decision of affirmance of the decision below, would you be contending that that was a constitutional exercise of legislative authority?
I would not contend, Your Honor, that that was an exception to the court's jurisdiction, because it would not be, in any sense, a jurisdictional directive. It would be a directive to this court as to how to decide the case.
Could you explain to Mr. Cromartie and Mr. Sultan how they are to explain to their client the difference between the legislation that I've proposed and the legislation that Congress has enacted?
The answer is that's their problem.
I would much rather, Your Honor, attempt to explain it to counsel than I would the petitioner himself. My position would be this, Your Honor. Any time any plaintiff comes into court, he must come into court with the expectation that that court or any appellate court can only act insofar as it has jurisdiction, insofar as it has the power to declare the law. And I would add that in this case, once you come to the point of Supreme Court review, there is a provision in the Constitution which gives Congress the authority to remove jurisdiction, and that cuts off the court's power. And at that point, he no longer has a right or an expectation to be heard. And I think, having had two chances below, that is not, Your Honor, an outrageous outcome or possibility. Perhaps to those who would like to see the court decide their way, yes. But I think given Congress's constitutional authority, that does not.
Apart from McCardle, you don't have any authority, though, for the constitutionality of legislation like the Clinton Amendment.
Your Honor, McCardle is the only case in which this court has expressly addressed the question of an affirmative exception. However, in numerous other cases, it has said that it may only act where it has, in appellate jurisdiction cases, it may only act where it has jurisdiction, that where Congress has not expressly provided for it, it cannot act. And in those cases, it has recognized Congress's power, I think, even though it was exercised in somewhat negative sense in that by not providing for jurisdiction, it set out exceptions to the court's jurisdiction.
I suppose the Judiciary Act of 1925 was a reasonably recent example of action of Congress under this provision of the Constitution, which took away the right of appeal to the Supreme Court of the United States from many different kinds of litigants, and substituted, therefore, only the privilege of petitioning for certiorari.
In numerous instances, Your Honor, in the late 19th century, for example, for a case to be heard, there was a certain monetary amount that had to be in question, and petitioners below that amount could not be heard on certiorari. I think that is, you're right, that's an example where Congress has limited.
Well, your example or mine?
Either yours is, and I think, my point is, Your Honor, it is, but it's not the only example that could be cited.
Mr. Kantner, don't you think that your position would be strengthened if Congress had enacted this without a particular case pending? Doesn't the fact that here we had a particular case pending for which certiorari had already been granted, doesn't this then come closer to violating the separation of powers than if Congress had enacted this without any particular case in mind?
I think not, Your Honor. First of all, in McArdle, Congress clearly had McArdle's appeal in mind when it acted there. In fact, the Supreme Court waited. It delayed conference on the case while Congress debated what to do about it, and then Congress acted to accept the court's jurisdiction, and the court acknowledged that to be a valid exercise of Congress's power and dismissed the case for one appeal.
But as petitioners have pointed out, in McArdle, there was still open access for review.
That's true as a fact, Your Honor. I think, however, the court's reference in its concluding paragraph was to the fact that its entire habeas corpus appellate jurisdiction had not been accepted. And I might add, Your Honor, at this point, that I think that is one possible approach if this court has any desire to perhaps give Congress some directions for the future concerning its independence, to give Congress some directive. It would be that one possibility would be that it could say that Congress could not act, for example, to deny this court the right to review any case, a habeas corpus case. I think that was the nature. I think perhaps the court was hinting at some limitation. I don't think it found dispositive the fact that McArdle had an alternative route to the Supreme Court.
In other words, you think the specific reference to habeas corpus in the Constitution itself had some bearing?
I think so, Your Honor. There's no indication necessarily of that in the case, but I think that is very likely. It was very likely a factor in the court's decision.
Given that in the very case, which is really the only case that Congress could find to support the Clinton Amendment, and I think the researchers of counsel have found no more in terms of holdings of this court, that in that very decision in McArdle, the Chief Justice noted that the regular appellate pathways remained in place. And given that in this instance, by your own statement, there will be no other way if we dismiss this petition for certiorari that Fenton can get review here, don't you think we should look more attentively at the question whether indeed Congress legislated in a way that compels the result you seek, given that the actual holding of Judge Scott below was a holding based on the Foreign Sovereign Immunities Act, and the act of state discussion was dictum?
In the legal sense, Your Honor, that's correct. However,
isn't that a sense that should concern us here?
Certainly, Your Honor, it is a concern. However, as Congress understood the case, the district court judge dismissed the case on both grounds. And I think Congress clearly intended for this amendment to apply to this case. And this court has said before that where Congress's intent is clear, it will not read literally the statute to bring about a result completely at variance with what Congress intended.
I thought the court said almost exactly the opposite in the Snail-Darter case.
No, Your Honor, I think not.
There, the court read the literal language of the statute, regardless of the apparent intent of some Congresses in its appropriation acts.
Your Honor, in the Snail-Darter case, as I understood it, the court said that it was a question of whether recourse to legislative history was proper. And it said that it would not ordinarily look to legislative history when Congress's statute was clear.
It didn't in that case, and it also didn't give any controlling weight to the appropriations activities of Congress either in the building of Tellico Dam.
But Your Honor, I think to read this statute on by such a literal method, on such a really technical meaning, would be to bring about first of all, to bring about a result so completely at variance with Congress's clear intent that recourse to legislative history is not only defendable, but is required.
When the words are clear?
I think, Your Honor, to the ordinary reader, the words are perfectly clear. Now, it's, as I say, I cannot deny that the technical holding of the decision below was dismissal on the grounds of the Act of State, on the grounds of Foreign Sovereign Immunities
And if
Act.
that's true, then the Clinton Act is simply inapplicable, isn't it?
But to say that, Your Honor, on review of this case, you will have to review the decision below on the Act of State grounds, because an appellate court, of course, has to review any grounds on which the lower court decision might be upheld, whether or not, in fact, the lower court addressed itself to that question. And I think, Your Honor, that is precisely what Congress did not want to happen
If the
here.
court should reverse, it need review only one issue.
Well, that's true. My point was that to decide for Fenton, you need to address all four of the issues. And that would include the Act of State doctrine. And I think review of the Act of State doctrine is precisely what Congress did not want to happen here.
But this case had already been decided in the lower court at the time that the Clinton Act was enacted. Is that correct?
I believe so, Your Honor, yes.
All right. And therefore, if Congress's intent was as clear and as plain as you read it, wouldn't the Clinton Act have been worded differently in order to encompass this case? It just said Act of State.
Your Honor,
And
as I say, the legislative
didn't decide
history,
on that.
in the legislative history, Congress refers to the district court's decision as dismissed in part on the Act of State doctrine. Now, perhaps they misunderstood the technical meaning of the word holding or grounds for dismissal. But I
So
think
it might have not been as clear.
in mind would bring about a different result. But I think that to read it that way and to bring about a result so completely at variance with what Congress intended is simply unjustified and uncalled for.
Uncalled for, Mr. Kantner, when what you're insisting on is Congress's authority to launch an assault on the appellate
Not at all, Your Honor.
authority of this court, and we now are being asked by you to give Congress its choice of weapons.
Not at all, Your Honor. That is not my intent whatsoever. I have suggested a couple of standards by which this court might attempt to limit the exercise of the exceptions power. After all, whatever statute Congress passes does have to be an exception to jurisdiction. If in any sense it eviscerates the court's appellate jurisdiction, then it cannot be characterized as an exception. It cannot be said to be a proper exercise of Congress's constitutional authority. Now the question is, how do you define appellate jurisdiction? So, you know, what circle, in other words, will we draw in order to determine whether what Congress has done is in fact an exception and leaves some residuum?
I guess your basic point is that if Congress had never acted at all, this court would have no appellate jurisdiction whatsoever.
Had they never acted, Your Honor, I think that would have been the result. But many
we
of
have
us,
no inherent appellate jurisdiction. That's your point.
the Constitution gives this court, Your Honor, no appellate jurisdiction unless Congress expressly provides for it.
And
But
what
Your
Congress can do, it can undo. Is that your point?
My point, Your Honor, is that Congress may make exceptions to the court's appellate jurisdiction.
Well,
and it's not
but
required for us to take
if no appellate jurisdiction exists at all except by congressional action, can't Congress go even further than that and just abolish all appellate jurisdiction of this court? Isn't that where your argument leads?
No, Your Honor, I think not.
Well, if you say there's no inherent appellate jurisdiction and no jurisdiction except that which Congress has provided, doesn't Congress have the power to remove what it has provided?
Perhaps, Your Honor, there is some meaning in the word vest in Article 3, which says that once Congress has given this court appellate jurisdiction, it cannot, by making an exception, remove that court's appellate jurisdiction entirely.
It did remove a great deal of its court, technically, again, its appellate jurisdiction in 1925, didn't it? And gave it certiorari jurisdiction instead.
Yes, Your Honor. My point is that Congress cannot remove totally the Supreme Court's appellate jurisdiction. It does have to be an exception. And by either of the two standards,
that argument.
by either of the two standards I propose in terms of limiting that power by defining appellate jurisdiction so as to provide a standard by which to determine whether an exception has been exercised, that is, either a group of cases such as Commerce Clause cases or active state cases, or the broader standard being perhaps the groups of cases as are set out in Article 3, under either of those two standards, the Clinton Amendment is a valid exercise, is an exception to the court's jurisdiction, and is a valid exercise of that constitutional authority.
Your adversaries have suggested that your theory of this court's appellate power in relation to Congress's regulatory authority is one under which a Congress which disagreed with the drift of this court's jurisprudence up to Brown could have prevented this court from reviewing the 5 consolidated cases that reached this court as Brown versus Board of Education. Would you acknowledge that to be true?
If that, Your Honor, is a different case because those cases were predicated upon an equal protection claim. And I would not tell Your Honor that a case that brought into question an independent constitutional provision was the same case as we have here. I don't know that Congress has the power via exceptions clause authority to violate independent.
Well, don't you think an ingenious lawyer would have had no great difficulty in bringing such a case under the Constitution, under the jurisdiction conferred by the Constitution on the Supreme Court?
Bringing which case, Your Honor?
The case testing the validity of the Civil Rights Act of 1964 was brought as an original action in this court. Not under some appellate jurisdiction conferred by Congress, but by the jurisdiction conferred by the Constitution itself, which concededly everybody would agree Congress cannot take away.
That's correct, Your Honor.
Well, couldn't the cases of Brown against Board of Education, they would have had different names, but don't you think it wouldn't have taxed the ingenuity greatly of lawyers, particularly from this great law school, to bring such a case as within the constitutional jurisdiction of the court as an original action between 2 states, for example?
Perhaps it could have.
Perhaps it could have, couldn't it?
Your Honor, yes. But my point is that no independent constitutional provision is alleged to have been violated here, and that, Your Honors, is a much different case than one where one could clearly point to an independent constitutional provision that was being violated. I would assume, yes, Your Honor.
So the applicability of the exceptions clause here depends on the fact that this particular litigation, which Congress would withdraw from this court's jurisdiction, doesn't happen to raise in the petition for certiorari a constitutional claim?
Your Honor,
is that what you rest on?
I would not rest upon that, Your Honor, because, as I say, I've simply cited what would be a different case and a far more difficult case to decide. The Clinton Amendment, on the other hand, does not bring that issue to bear. If it did in some sense, then we would have a different case.
I see stronger social policies, but I'm not sure where the constitutional ingredients cut more finely if we understand that in the case I've supposed, either 1 or 2 lower courts would already have had a chance to deal with the constitutional questions presented.
Well, again, Your Honor, I've suggested 2 possible limitations. The fact that whatever statute Congress passes has to be an exception, and 2, that no independent constitutional provision be violated, to show that Congress may not, in any sense, set out to, in any sense, undermine the court's essential function.
Well, your brothers say that's precisely what Congress has done in this case.
I think not, Your Honor.
Well, you think not, but that's what your brothers assert very strenuously.
Your Honor, congressional motive is not the measure of its constitutional authority. However, the purpose and the effect of the Clinton Amendment, passage of the Clinton Amendment in this case, indicate that the Clinton Amendment is supportive of and consistent with notions of separation of powers and not undermine it, in any sense cannot be said to undermine them. The need of this nation for a comprehensive energy policy is an important need. It will the establishment and furthering of that policy will require trade-offs between sectional interest, between consumer industrial interests, and many others.
Sectional interest, you said?
Sectional interest, Your Honor. North and south. Between the north and south, Your Honor. East and west.
I see.
Your Honor,
Mr.
those... Yes, Your Honor.
No, go ahead, Mr. Kennedy.
No, I'm sorry to interrupt you, Your Honor.
No. You go ahead.
Those trade-offs and the sacrifices that will be called for are inherently political. My point is that the Clinton Amendment does not disrupt the court's essential adjudicative functions but it does provide Congress some time to pursue political goals in a political fashion. And that, I think, is the very nature of the compromise that is referred to by the notion of checks and balances. That is, that each branch should pursue its proper role, not that any one branch should be preeminent.
Mr. Kantner, before you sit down, may I ask you one question on the separation of powers doctrine that you're now urging conformity with? Isn't there something strange about the fact that Congress in the Clinton Amendment asserted that it was protecting the authority of the United States to pursue vital foreign policy objectives in an orderly way in a piece of legislation which the President, who has paramount authority in this area, tried to veto?
Your Honor, the President certainly is the primary official responsible for foreign affairs, but the Constitution does give Congress a role. Moreover, it is not solely questions of foreign policy which are involved here. The energy policy that Congress is attempting to establish and for which it seeks time to establish and therefore would have this Court not exercise jurisdiction here, also has tremendous domestic ramifications, and we cannot look at the Clinton Amendment solely in terms of foreign policy. Thank you.
Thank you, Mr. Kantner.
Thank you.
You may proceed.
May it please the Court. My name is Marcia Remai. In addition to the issues addressed by my colleague, Mr. Kantner, there remain to be considered in this case the very difficult and complex problems created by the fact that petitioner's antitrust claim invites the federal courts to scrutinize the conduct of a foreign sovereign. Recognizing the difficulties that such an inquiry might generate, both this Court and the Congress have responded by fashioning a body of law which serves to narrow the role of the judiciary in such disputes. That body of law builds upon two fundamental legal principles: sovereign immunity and separation of powers. The former is codified in the recently enacted Foreign Sovereign Immunities Act, and the latter has underpinned this Court's formulation of the Act of State doctrine since 1964. It is to these alternate and equally dispositive grounds of decision which I shall now turn. In 1976, Congress enacted the Foreign Sovereign Immunities Act, which immunizes from the processes of American courts the governmental conduct of a foreign state. There can be no question but that the pricing and production decisions challenged by petitioner's antitrust claim are the embodiment of a political choice by the state of Atlantis to seize control of its most valuable natural resource from Western nations to assure the development and utilization of that resource consistent with national interests. In a word, price and production were not set at commercial levels, but at levels consistent with three governmental interests: in securing reparations for what Atlantis perceived to be the pre-1971 practice of Western nations to exploit those resources in a way that deprived the Atlantean people of their just entitlement to the results and the revenues of those resources, to effectuate a redistribution of wealth from the industrialized world to Atlantis so as to enhance Atlantis' national security, and thirdly, to strengthen and solidify Atlantean political recognition by increasing Atlanteans' impact on matters of world affairs.
Well, let's assume that every single thing you've told us so far is the full and total and actual truth. Does that make any difference under the statutory definition of commercial activity, which says the commercial character of an activity shall be determined by reference to the nature of the course of conduct rather than by reference to its purpose?
Yes, Your Honor, those considerations make every difference because
You're talking about the purposes.
they may in fact be purposes as well as determinative of the nature of the transaction.
The nature of its conduct was selling oil, wasn't it?
The nature of the conduct that is challenged by petitioner's antitrust counterclaim are the pricing and production decisions
Selling oil at a
of
particular price. what your brothers say is a very high price, an illegally high price.
Yes, Your Honor. In order to prevail on its antitrust claim, the petitioner will have to establish that the pricing and production policy of the state of Atlantis was invalid under American antitrust laws.
But isn't selling oil at any price commercial activity?
Not in the context of this litigation,
Isn't
Your
that
Honor.
its nature?
Given the very, first of all, the fact of the matter is that it is extremely difficult to draw the line between commercial and political enterprise when one speaks of a developing nation in a position such as Atlantis, where the utilization and development of a natural resource may be the only means available to effectuate political change. Given that difficult problem, to conclude that the decisions, the pricing and production decisions herein involved are commercial in nature would be to impute to Congress an intent that the immunity provided for in the Act was never intended to apply to developing nations such as Atlantis. And where there is no indication either in the terms of the statute itself or in the legislative history which accompanied its enactment that such a result was intended, it ought not to be inferred.
I would have thought that if the drawing of the line between a commercial and a political activity were as difficult as you suggest, we at this court ought to be very deferential to the concurrent determinations of two lower courts. Would that be a ground that you would urge on us or not?
Well, certainly, Your Honor, to the extent that this court felt that that were possible, then yes, because it was the conclusion of the lower court that this activity in nature was political. But I think that Congress was not unaware of the difficulties that this determination might create, since the legislative history indicates that Congress did intend to give the courts a certain amount of leeway.
So you see it as an issue of law?
Yes, I think it is an issue of law.
Ms. Verma, if as you contend the purpose of this was to aid developing countries and that it was not commercial activity, but to conserve its resources and, to, as I said, aid developing countries, wouldn't your argument be strengthened if these resources were going to be used for some of the less affluent countries instead of selling it all to this country at a very high price, where dollars and cents entered into it very prominently?
Well, dollars and cents, Your Honor, are at the very heart of the political and ideological goals of not only the state of Atlantis, but all the member states of the OPEC cartel. And to the extent that the consuming world consists of developed countries, I don't believe that that negates the clearly governmental nature of the conduct that Atlantis has undertaken in concert with its colleagues in the OPEC cartel. I believe that, whereas I don't think it's the case that the Foreign Sovereign Immunities Act was intended to come to the aid of developing nations, my point is simply that there is no indication in the Act that there was an intent to discriminate against those nations. And when one speaks of the Third World, where the commercial political line is difficult to draw, to conclude that the challenge to conduct, which goes to the very heart of governmental policy, is commercial, would be to impute such a discriminatory intent to Congress.
Mr. Remai, up until throughout most of the period that's relevant to this litigation, at least up until the end of 1974, it was the fact, was it not, that the decisions taken by Amar were decisions which required the concurrence of at least some American directors?
Yes, Your Honor, that's true.
And to the extent that that was true, clearly the decisions taken by the American directors can't be attributed to anything other than the ordinary commercial purposes which would animate American businessmen operating in the Middle East.
I don't think that that's necessarily the case, Your Honor, given the wake of constraint that operated in the environment at the time. I think it is more appropriate to view the decisions of the Amar board as the result of the expropriation measures of the state of Atlantis itself, undertaken at the outset in 1971. And that is the case because it is conceded by all parties that the decision of the American directors to participate in the two-thirds majority, which no more than rubber-stamped the decision of the state of Atlantis to comply with open directives, was compelled by the threat of future expropriations on the part of Atlantis itself. Furthermore, with respect to the Foreign Sovereign Immunities Act, foreign state is defined as either the foreign state itself or its agencies or instrumentalities, and at all times relevant to the petitioner's antitrust claim. Amar was, by virtue of the majority ownership by the state of Atlantis, the agency of the state of Atlantis, and therefore able to claim the immunity that the Act provides.
That's true as a matter of statutory definition?
Yes, Your Honor.
Despite the requirement of a two-thirds vote?
Yes, Your Honor, that is true. The statute clearly provides in the definition section that foreign state...
Majority ownership?
Yes.
Do you have any difficulty with the applicability of the Act to a course of events which antedated the Act's enactment, and indeed to litigation which commenced prior to the Act's adoption by Congress?
No, Your Honor. I think that is because, generally speaking, this Court, whereas it will not impute a retroactive intent unless the language of the statute makes that clear, here that indication is clear. Moreover, there is no compromise of antecedent rights because it is the position of Amar that it would have been immune under prior law, just as it continues to be under the Act.
You're relying on the preambulatory language which directs courts to determine issues of sovereign immunity and the like in conformity with the principles of this Act.
Yes, Your Honor. It refers to claims of immunity and measured by the time that those claims arise.
But if you follow out that view of the Act, then aren't you caught by a different difficulty? Aren't you therefore required at least to consider whether the Foreign Sovereign Immunities Act doesn't absorb and, as it were, dissipate what had been theretofore the independently developing active state doctrine as reflected in Dunhill, which was decided a few months before the adoption of this Act?
I don't think so, Your Honor. First of all, because the questions which the Foreign Sovereign Immunity Act address are wholly different from those which this Court or other federal courts address in applying the active state doctrine. Sovereign immunity concerns itself primarily, if not solely, with the sovereign status of a litigant in determining the jurisdiction, the power of a court to determine a case, whereas...
Regardless of the conduct
yes,
involved in
the
the substance of the plaintiff's claim.
Yes. Whereas the active state doctrine, which concerns itself with questions of justiciability,
Right.
asks this Court to inquire into whether or not a determination on the merits could so seriously interfere with political prerogatives in an area that's committed exclusively to the political domain, that is, foreign relations, requires abstention. And the legislative history makes clear that Congress did not intend to affect the operative scope of the active state doctrine, simply recognizing that the power to decide and the wisdom of decision are different inquiries.
In view of the fact that Amar brought its action against Fenton in the courts of this country, aren't you barred by Section 1607?
I think not, Your Honor. First of all, to the extent that a direct claim could have been maintained, that is the first exception contained in Section 1607, referring to the commercial political problem which we've just finished discussing. Beyond that, the ability to maintain a counterclaim rests on the petitioner's ability to demonstrate that the counterclaim arises out of the same transaction or occurrence as does the principal claim, that is, Amar's breach of contract claim. The antitrust claim concerns numerous incidents covering a lengthy period of time and implicating the conduct of many actors not even made parties to these proceedings. That is, all the open nations. The breach of contract claim, on the other hand, concerns itself with a single transaction executed and completed in the year 1975. For that reason, it would be the respondent's position that the antitrust claim does not arise out of the same transaction or occurrence upon which Amar's breach of contract claim is based.
But it all led up to the same contract. Isn't that correct?
The pricing and production decisions? Yes, Your Honor, but I think that given what Congress has set before this Court in terms of its clear indication that it would not have this Court decide this case, notwithstanding whatever constitutional difficulties there are with the Clinton Amendment, it would be fair to read that section in light of these indications as not intended to apply to this case, and that the transaction or occurrence test has not been fully satisfied here.
If you lose all else, Ms. Remai, including this issue, even under 1607, you would be limited the defendant would be limited to a set-off, wouldn't he not?
Provided the set-off did not seek a relief differing in kind.
Yes, but as I say, even if you lose everything else, including the applicability of 1607, under 1607, the defendant would be limited to a set-off, would he not?
Yes. If that exception were satisfied, the limitation would be to a set-off.
Right.
If the counterclaim
Under C,
1607,
under subsection
right.
C.
If 1607B is satisfied, which it is the respondent's position it is
I
not,
understand that.
then the full amount of the counterclaim for affirmative relief would be permitted. The set-off provision is a third and alternate form of exception to the broad immunity otherwise granted. The conclusion then seems reasonably clear to the respondent, Your Honor, that at most the commercial transactions through which the political choices of the state of Atlantis were effectuated provide a backdrop to what is otherwise clearly governmental conduct. But aside from the Foreign Sovereign Immunities Act, this court has before it a judge-made body of law which is also designed to be responsive to the problems created by a case which invites scrutiny of the governmental acts of a foreign state, and that is the Act of State Doctrine. The Act of State Doctrine is a rule of abstention whereby the federal courts refuse to adjudicate a case where a consideration on the merits runs the risk of interfering with the ability of Congress and the executive to resolve a problem of exclusive political concern, here of foreign relations. It is clear that the facts of petitioner's counterclaim fall squarely within the protective principles of the Act of State Doctrine.
What are the roots of the Act of State Doctrine? My colleague Justice Kravitch asked you that before. Are they in the Constitution, or are they in international law?
Well, the most
or in the
recent...
separation of powers inherent in our Constitution, or where?
Whereas the Act of State Doctrine is not compelled by the Constitution, this court indicated in Sabatino that it has constitutional underpinnings emanating from the separation of powers principle. In other words, it is based upon a notion of deference where a particular controversy in fact involves a question that is committed to coordinate branches of government. So it is a rule of federal common law as opposed to a rule of international law, because the concerns weighed in the Act of State balance are American concerns. Concerns on the one hand with deciding a particular case, balanced against concerns for preserving the ability of the political branches to act on a problem of political concern.
Do the courts of other nations have any such analogous doctrines that you know of?
The court in Sabatino pointed out that there are many courts in many nations that do not recognize the Act of State Doctrine.
Well, that's not my question. Not that
not
others
know.
do not. Do you know any that do?
No, I don't, Your Honor.
Yeah.
Ms. Remai, do you think perhaps this would be a good time for this court to join the majority with respect to the Act of State Doctrine?
If its foundation is as shaky as even
To
you have
join,
indicated.
beg your pardon, Your
To
Honor?
join the majority of jurisprudences which do not recognize the Act of State Doctrine.
I don't think so, Your Honor. I think that this case would be a particularly inappropriate one for joining that majority. Given what respondent feels are the particularly delicate political ramifications of an adjudication on the merits of this case.
Ms. Remai, if my recollection is correct, the Department of State authorized the Solicitor General at the time of the Dunhill case that in the Department's view, the Act of State Doctrine could be quietly jettisoned without any embarrassment to the foreign relations of the United States. Given the roots of the doctrine and this Court's concern with problems of separation of powers and the paramountcy of the executive's responsibilities in the foreign area, don't you think that should be a very strongly impelling view, which would lead us now to perhaps reconsider the doctrine, even if it may be an embarrassment to your client?
Or even some of us who joined the Sabatino decision?
I don't think there's any need for that kind of embarrassment, Your Honor. First of all, because the letter in Dunhill, of which Justice Pollack speaks, referred to an endorsement of what four justices in the Dunhill case suggested as a commercial exception to the Act of State Doctrine. And to the extent that the activity involved in question here is political, it would not come under the terms of that commercial exception. But even if this Court...
Did you read to the end of the letter?
I did once, Your Honor, yes.
I think there was a coda, if I recall it, which indicated that if one went beyond the particular question of the commercial exception, the Department of State was of the view that the doctrine itself was one which perhaps no longer commanded, except in the view of certain of the members of this court, an absorbing authority.
Well, that may be a factor, Your Honor, but I do not believe that the executive, by simple stipulation, can convert a non-justiciable question into a justiciable one.
Yes, but if the foundation of the doctrine is deference to the views of the executive, and if the executive now says, I've changed my views, I don't think this is an important doctrine, then doesn't that greatly weaken the foundation for the doctrine itself?
Well, I think not, Your Honor, partially because the position that may have been felt by the administration at the time of Dunhill may no longer be the same, especially in light of current developments. The President may no longer be in a position to say that he would have his court determine.
The President who vetoed the Clinton Amendment?
The same President who also addressed to the oil-producing nations that they please maintain current supplies in view of the response to the Iranian problem. Yes, Your Honor.
Well, do you think the continuation of this doctrine should depend on the specific identity of who might or might not be president at any particular time, or even who might or might not be Secretary of State at any particular time?
No, Your Honor, that is precisely the contrary to what I suggest. I think because it is ultimately a judicial responsibility to make this justiciability determination.
To make decisions for the executive?
No, Your Honor. To decline to adjudicate a case where the possibility of frustration emerges on a case-by-case basis, not only to the executive, but to Congress as well. I believe the Sabatino Court was concerned not only with embarrassment to the President, but to Congress. And Congress, in this case, has made its concern for a decision on the merits quite clear and quite urgent in the legislative history that accompanied it.
I think we can all agree with that.
Yes.
Ultimately, your position then is, the first position is that Congress should assume this court's responsibilities by requiring us to dismiss the petition for certiorari. But if we're unwilling to accept that, then we should assume the President's responsibilities by application of the active state doctrine. Is that your view?
No, Your Honor. I think that by applying the active state doctrine in this case, this court assures that it does not assume the position of the presidency by leaving the President free to act as he must in areas of foreign policy, because a decision on the merits, a finding of liability, for example, is likely to be viewed as an affront to the political and ideological goals of all the open nations, inviting the possibility of some form of retaliation, thereby strangling current executive and congressional efforts to arrive at a comprehensive energy policy. By declining to decide, this court leaves the President and the Congress free to act in an area that is committed to their exclusive concern. So abstaining is not the equivalent of assumption of the executive or the congressional role. It is, in fact, a recognition that this court is unable to decide political controversies within the institutional confines that exist in the judiciary. Furthermore, regardless of the outcome of the merits, in fact, a finding of non-liability might equally embarrass the executive and Congress in the conduct of foreign relations, given that at that point the executive would not be in a position to say that the conduct of the open nations was invalid as a matter of American law.
If you lose this lawsuit, you're not going to make that argument to the district court, are you?
No.
But you hope there'll be a finding of non-liability.
Yes, that's true, Your Honor. In the final analysis, then, the separation of powers principles which underpin the active state doctrine are, in a measure, concerns for the unfairnesses that could result from a judicial resolution of a problem that, in fact, is capable of solution in the political forum alone. Petitioner, in insisting that fairness requires a disposition of its case on the merits, asked this court to overlook the more far serious unfairnesses that could occur to all Americans in the event such a disposition were to be ordered. The active state doctrine, then, is simply a vehicle for assuring that political questions will be decided in the political forum. In summary, then, Your Honors, the respondent has set out for this court a composite body of law which points to but one resolution of the instant controversy. The judgment of the Court of Appeals dismissing petitioner's counterclaim must be left undisturbed. Although the various portions of that body of law emanate from different sources and build upon different legal principles, the theme running throughout the whole is a constant one, that international political controversies cannot be resolved in the federal courts in the guise of private disputes. In the final analysis...
And yet, isn't it true that foreign countries come to this country and go into courts with their disputes? The FISA case was a good example, wasn't it?
Yes, Your Honor, but that case did not raise the potential problems in terms of frustrating the ability of the political branches to resolve questions of foreign relations that does the instant controversy, the active state doctrine, questions of foreign sovereign immunity having no relevance to the Pfizer-type case. In the final analysis, then, and with all due respect to this Court, whatever justice is to be done in this case can only be rendered in the political forum. Thank you.
Thank you, Ms. Remine. Mr. Sultan, you have, I think, 3 minutes.
Your Honors, unless the Court has additional questions for Petitioner, we would waive back the balance of our time.
I have one question I'd like to put to you, if I may, Mr. Sultan. Your brief characterizes McCardle as an obsolete case. At least I so read the language. Which asks us not to rely on the dictum of an obsolete case and thereby cede our independence to Congress. That is your position, is it, with respect to McCardle?
Your Honor, it is our position, as my colleague indicated, first, that McCardle was a very different case. It was decided in unique circumstances. It did not foreclose all avenues of review to this Court. To the extent that this Court found that the language of Chief Justice Chase in that case, to the effect that the Congress may make exceptions to the appellate power of the Supreme Court, should be taken as a holding of that case, we would argue that that case must no longer stand for that proposition.
What would you do with the more recent language of one who I believe is properly revered in these halls, Mr. Justice Frankfurter, who cited McCardle as authority for the proposition that Congress can withdraw a case even when it is sub judice?
Yes, Your Honor.
Which I believe is Latin for being here.
Freely translation.
I think it means that's where we are today, Your Honor, yes. We would assert that Justice Frankfurter's viewpoint in that case, and there are a number of other justices pointed out by respondents who, in concurring or dissenting opinions in this Court, have read McCardle that way, that those views should not be endorsed by the Court as a whole. To do so would be to undermine the delicate balance of powers and the separation of powers which forms the very basis of our constitutional system. To the extent that McCardle must be read as Justice Frankfurter there suggests, this Court must not take such a view today.
Well, even I thought your second point was, even if we do take such a view and say and recognize, if you will, that that is precisely what the McCardle case decided, that nonetheless that was a product of a particular rather atypical era in our country's history, the Civil War era.
Absolutely, Your Honor. For that reason, it should be limited to its facts.
You think the Court today would rule the same way in McCardle?
Well, Your Honor, about a dozen years ago, Justice Douglas suggested that it would not. I would be very reluctant to speculate as to the views of the members of this Court.
Well, I thought that was your very point, that it wouldn't today. that this should be understood as a particular product of the post-Civil War Reconstruction era.
Your Honor, my point was that this Court should not and must not make such a determination. Justice Kravitch asked me if it was my opinion that this Court would rule differently, and I would offer no view.
Well, you do hope to win your case, don't you?
Yes, Your Honor.
Anything further? No. Thank you very much.
Thank you, Your Honor.
Thank you. All of you, the Court will take a short Counsel and ladies and gentlemen, the court has deliberated. As I think everybody in this room knows, it was no part of the court's duty to reach a decision on the merits of the case argued here tonight. If it had been, I'm sure we'd still be out there arguing with each other. Our function was limited to reaching decisions on the quality of the oral arguments made here tonight and of the briefs that were submitted. And even that task was an extremely difficult one. After I've made these announcements, I think my colleagues and I perhaps will have a few words to say, but you're interested now in what our decision was, and that I'll give you. We had 3 awards to make. The first award we were asked to make was, and the decision we were asked to make was the best individual oral argument tonight. And our decision that the best individual oral argument this evening was made by Mr. James Sultan. I should add that the court had great difficulty in deciding between Mr. James Sultan and Miss Marcia Remai for that award. And the second decision we were asked to make was which was the better briefing team, judging the petitioner's single brief and the respondent's the petitioner's brief and reply brief and the respondent's single brief. In that decision, we indulged in ourselves in something that I'm sorry to say we're never allowed to do on our court. We held that this was an absolute tie. And finally, we were asked to decide the winning team based upon the briefs and the oral argument. Our decision was that the winning team were the counsel for the petitioner, represented here tonight by Mr. Eric Cromartie and Mr. James Sultan. Judge Pollack, would you like to say a few words?
I will add just a word, Justice Stewart. First to say what an extraordinary pleasure as well as privilege it has been to serve on this panel this evening and to hear such extraordinarily able presentations of very, very difficult problems. It is a level of argument that gladdens the professional ear, and from the point of view of the briefs, the professional eye. And I am warmly congratulatory of all of the members of both teams, not alone those who participated in the oral argument, but those who labored
not quite anonymously, but not out loud on the briefs as well. With respect to the oral arguments, as Justice Stewart said, it was a very, very narrow judgment, as among us, between Mr. Sultan and Ms. Remai. But having said that, I want to add that the level of argument of Mr. Cromartie and Mr. Kantner was also, in our judgment, very, very high. We're talking about very, very marginal distinctions between people of awfully high quality, and their quality is as manifest to all of you as to us. I guess I would say finally that the stormy applause with which our decisions were greeted is a gratifying reaffirmation of the support which the judiciary has, at least in this school. Whatever the fate of McCardle or Sabatino, or even the new and dubious Clinton, I'm delighted to know that Article 3 remains alive and well in the Harvard Law School.
Judge Kravitch?
Well, this has been a very exciting evening for me. I've waited a long time to come to Harvard Law School. And in 1941, I was advised, very politely, that Harvard Law School did not admit women students. So in my case, it's better late than never. It was primarily exciting to me tonight, though, to see the level of competence, the high quality, both in the briefs and demonstrated in the oral arguments by all of the participants. And it made me feel very exhilarated to read them, to see the understanding of very, very complex, complicated issues, and to listen to the arguments and the way that all four responded to the questions from the bench. I wish that every brief that I read on the Fifth Circuit Court of Appeals was of this same caliber, and that every argument was also. And I want to congratulate these four people, the faculty, and everyone else who has participated in this evening tonight. It's a tribute to the legal profession and to the futures that you'll all have.
Thank you, Judge Kravitch. Thank you very much, Judge Kravitch and Judge Pollack. And ladies and gentlemen, my colleagues have left me very little to say. I can only agree with both of them. It is heartening, as Judge Pollack says, to come into a courtroom where you hear applause. I've never heard it in our courtroom. And also, indeed, to come into a courtroom where I got promoted. We appreciate your hospitality to us this evening, and we all three have been extremely impressed by the high quality and the high level of the advocacy manifested here tonight, both orally and in writing. In a system of law such as we have in our country, for better or for worse, a system, first of all, of common law and our system of constitutional law, so much of the law reflects the quality and caliber of the advocates appearing before the courts who make the law. And it's very heartening to know that reflected here this evening is the future of that process of development in in our country, and it's nice to know that the future is in such firm hands. Congratulations to all of you.